Good afternoon, and thank you for joining us today for our Project Closeout Launch Guide, which is coming to you during our 6th annual Construction and Skilled Trades Month. I am Chris Atchison. I'm the president of the BC Construction Association. And before we begin, I'd like to acknowledge the Lekwungen peoples on whose traditional territory I live, work, and play, and the Songhees, Esquimalt, and Wasanich people whose historical relationship with this land continues to this day. For those of you who are new to our organization, there are just a few main points that I ask you to remember about the BC Construction Association. We're the only provincial construction association representing all employers across the industry, regardless of their labor affiliation, union and open shop. We're here for you. We're the only association connected to every community in British Columbia via our 4 regional construction association partners. We represent the 25,000 contractors across BC who primarily build industrial, commercial, institutional, and multi-unit residential housing. And our goal is a productive and resilient construction sector. We have a very unique and effective association model. In each of our 4 regions across the province, we have regional construction associations who serve you and our local members who are boots on the ground, telling us what matters to the local businesses. Our strategic plan is based on 3 primary pillars: building our workforce, reinforcing our communities, and supporting construction delivery, which is the primary focus of today's webinar. Our efforts towards prompt payment legislation are obvious, and we're working towards pressuring the Attorney General to introduce prompt payment legislation. And until we've achieved that goal, there is a need for a guide like this. So without further ado, I'd like to introduce Katie Fairley, our standard practices consultant, to talk to you about the guide. But before I do that, I need to thank the BCCA Board of Directors, our Standard Practices Committee, and our Closeout Guide Task Force for bringing this initiative to fruition. It's industry volunteers like these who are a testament to the leadership this sector deserves. Now over to you, Katie.
Thanks so much, Chris, and thank you everybody for attending this launch webinar today. So our agenda, we're going to go through kind of the introduction to who is the task force, what kind of process we followed to develop this guideline. We're going to reinforce the idea repeatedly of the need to read your contract and all of the contract documents, including and most especially the supplementary conditions and the prime contract. We're going to go through some of the statutory and contractual obligations and rights that exist, and kind of further emphasizing the difference between the two. And we're also going to talk about the release of holdback funds, and as well as progressive release of those holdback funds for subcontractors. And then we'll go through some of the items like O&M manuals and deferred work, and we'll touch on best practices in each of these areas. But I'll just say, maybe as something of a warning, a lot of the items that we cover in this guide, might be easier said than done. And, the best practices that exist are just best practices. And we know that our industry is all about relationships. I am going to let the task force members themselves speak on the specific activities within the guide, but otherwise I'll be the one kind of walking you through, again, kind of that administrative structural elements that relate to the guide. So first up, I'll just note that we do have another guide as well that has been in existence since 2005, if you can believe it, and that's the Guide to the Builders Lien Act. It's an outstanding resource, and you can access that on our website. And it's really the companion, the sister guide to this new one, the Guide to the Closeout of Construction Contracts and Projects. So this guide today that we're talking about, the intent is not to be a how-to with the Builders Lien Act, but it is, focused more on that closeout, and its sister companion guide is focused on the BLA. And both of these guides are approved by the BCCA Board of Directors, as well as the Standard Practices Committee. So I am very pleased to introduce our task force members. We have Terry Brown with STBR Consulting. He, like me, is a recovering general contractor and has been in our industry for years in that role. We have Randy Noble, Chief Estimator with Hool Electric, who's coming to us live from a construction site and maybe in a closet somewhere so that he can participate in this. So thank you so much, Randy. We have Eric Lindockin, who's a Senior Project Manager with Kinetic Construction, also a general contractor. And we have Tim Sportschutz, who is our reviewing legal counsel and a construction lawyer by trade. And then myself as well, again, the industry standard practices consultant. So our process, we met weekly for about 2.5 to 3 months. So you can imagine how busy these folks are, and they volunteered, their time during that process. We also then involved Tim to provide our legal review, which of course generated more meetings and more conversation. And that was followed by a review by our standard practices committee, and finally the board of directors and the executive of BCCA. So there's been a lot of eyes on this guide, and we're really pleased with the final outcome. So why did we need to produce this guide? There was something in existence that was developed in 2017, and it was intended to be procedures for the closeout of construction projects. But when we took a look at it, we realized that we needed to get into a bit more of the specifics around closeout to help subs and GCs specifically. So I think we all know project closeout is one of the hardest parts of a construction project and the contract. So this is an opportunity for us to reinforce best practices. We needed to take a look at those procedures that were developed in 2017 by the same task force because of the new Ready for Takeover milestone in the CCDC 2 2020, as well as the CCA 1 subcontract released in 2021. So one of the main purposes of this guide is to reinforce not just to you, the readers, the subs, and the GCs, that language and terminology matters, but also to owners and consultants. While the purpose of this guide is for industry, it certainly can be a resource for them as well. And as Chris touched on, and most importantly, probably about 65% of this guide wouldn't exist in its current format if we had prompt payment legislation in BC. So it is the #1 advocacy issue for BCCA, as well as the Regional Construction Association. And if you want prompt payment, reach out to your MLA. Tell them that this is something that industry needs, because it absolutely is. So, so with this, I'll just outline briefly some of the assumptions that our guide makes. Our guide makes the assumption that trade contractors are in contract with the contractors, the general contractors, not the owner. We make the assumption that it's a CCDC contract in use, and more specifically, the CCDC 2 2020. And we're also making the assumption that the construction contract administration is the consultant's responsibility, and they are acting as payment certifier as defined under the Builders Lien Act. The CCDC 2 2020 is still relatively new, despite being available for 2.5 years. So not all of you might have completed or are undertaking a project under it right now, but it is, the primary contract that's out there. And of course, people will be using it more and more over time. So if you take away anything from this guide, aside from reading your contract, so that's probably about the 3rd time I've mentioned it, and we're going to keep going with that, is that critically and uniquely, BCCA is advising industry to complete its contractual and statutory obligations separately until such time as we have prompt payment and lien reform in BC. And that's because there are different timelines, different certificates to be issued, and potentially and critically different requirements. So what that means is that you could be submitting, an email request for your certificate of completion under the Builders Lien Act in one email, and then you might be also right afterwards be submitting a separate email stating that you've achieved substantial performance of the work as defined in the contract. So wrap your heads around that now, but that is the main thrust of this guide. So like I said, that means you're going to be submitting multiple requests, but that's how you're best going to be able to protect your rights in both instances and achieve those closeout milestones. So the guide is jam-packed full of activities and deeper dives into those topics. We're only covering a couple today, and really also this guide, as we wrote it, it's intended to be a find and search or a search and find. We don't expect everybody to go through and read 22 pages. You're far too busy for that. And really, we want you to be reading your contracts, not reading a guide. But as you need help or you want more information, you're able to go find that activity, find that deeper dive that's going to help you. I'll give a brief refresher here for those of you who are not as familiar with the new Ready for Takeover milestone. I'll just say, Terry Brown, he's on the line, one of the task force members. Terry, if you have anything you want to add after I cover off this, you were involved in actually drafting the language in CCDC 2 2020. So if I've missed anything, feel free to jump in. But Ready for Takeover is now the major contractual milestone that's outlined in CCDC 2 2020 and CCA 1 2021. So there is no money tied to achieving it. It's basically the owner gets their asset. Pretty simply, it's they're able to take it over, and it's at such a state that they're able to use it. Very importantly, watch those supplementary conditions. A lot of what I've been seeing out there as I've been reviewing supplementary conditions from various public sector owners and private sector owners, they're twisting the definition of Ready for Takeover and its requirements into something closer to total or final completion. So, make sure you've read through those because, like I said, it's the major contractual milestone. So the other part of it, because here's the rub, owners want their asset, contractors want their money. So, like I said, so I think keep that in mind as you start getting used to that. And Terry, is there anything else you want to add around that Ready for Takeover closeout milestone?
No, that sounded good, Katie, other than this is new for all of us, for owners, consultants, and contractors. And we are in a transition period. So as Katie said, you've got to become familiar with your contract and the supplementary conditions. And there'll be an educational process going on in the near future within the next year or two as everybody adapts to the new way that we're going to be doing business with a standard CCDC 2 document.
Yeah, that's a great point. And I think, Terry was speaking about, kind of that informal education that goes on as you work through a project. But, your local construction association has been having and continues to have education sessions about CCDC 2 and CCA 1. So definitely, contact them and, get familiar with this concept because it's coming for all of us. So, we've shared with you earlier today a copy of the guide, and if you opened it, you'd be shocked to see the color that is contained within the guide, and that is on purpose because words matter in our industry, definitions matter, and this is something that we're trying to drive home as well through this guide, because as we were developing it, we realized that there is different definitions as we talked about different items. So specifically, we developed, our own, our own definitions. We also had Builders Lien Act information, and then finally we have standard definitions under the CCDC 2 2020. So we were also highly specific when we were using language like shall and must and will and should. So should is a best practice, must and will are contractual in nature, and then shall is related to the Builders Lien Act. So as I said, and I've mentioned it a couple of times, what is statutory? So in our context within the guide, it means relating to or created by statutes and laws. And in our case, specifically the Builders Lien Act. Because I do believe it is a matter of when we get builders prompt payment legislation, we are going to see that also become a statute enshrined in law. And importantly, a lot of you probably already know this, there is no contracting out of the BLA. It is what it is. I'm sure Tim will speak to that as well, but it is what it is. And that's why we're so desperately need prompt payment legislation. So contractual means just that, means it's a requirement that is included in a written contract. And that means all of those contract documents, including the supplementary conditions. And here, I'm going to hand it over to Randy to talk about the all-important concept of read your contract. And that is activity number 1 that everybody should be undertaking. And Randy, if I could have you maybe speak a little bit about why that's so important.
Sure. Thanks, Katie. Any of you that have worked also as an estimator know the importance of reading the contract early on in the game to make sure that you're picking up any costs that may be associated with the project that are tied into that contract. And you always want to start with the contracts right at the very top level of the project. So you want to be able to review that head-end contract. And if you need to get a redacted copy to be able to read that head-end copy, that redacted copy still contains the content that you need so badly to review. If you're dealing with a contract that is a CCDC contract, almost assuredly, you're going to be looking at having supplementary conditions. And the supplementary conditions in and of themselves are where the faults lie and where you need to focus your efforts. The CCDC contracts have all been written fairly for all parties involved. The purpose of the supplementary conditions is to make some of those conditions a little less fair to another party. And very likely you are going to be that party. So spend your time on the supplementary conditions, read them in conjunction with the CCDC contract so you understand them in context. If you're a member of a trade and you're bidding as a subcontractor, if you're a member of a trade association, quite often now our trade associations have libraries of onerous contracts that have already had input from lawyers. So look into that library, make sure that the contract that you're reading isn't one of those onerous contracts. And if it is an onerous contract, then try to work your way through the clauses that are causing you a level of difficulty before you engage in the job. Remember that navigating the contract is a key step to be able to do. So being able to understand the contract, find the information quickly, and know when and where to reference it is a really helpful way for you to be able to manage your project. And at the end of the day, if what your contract is looking like in front of you is too confusing or too hard to read, and you need to involve a lawyer, by all means do so. Once you've committed yourself to that contract, you are then committed to the terms of that contract and you are held to them. So if it poses a danger to you, I would recommend you just don't bid the work. And
yeah, fantastic. And what would, oh, sorry, Randy.
Sorry.
Well, I was going to say, and by the way, you look great. So thank you again for coming to us live from a construction site. But yeah, what would you say if a subcontractor is getting the runaround from a GC about getting that copy of a prime contract when a flow down clause exists?
Yeah, if the subcontractor cannot get a copy of a signed contract from a prime contractor, and they're worried about a flow down clause, and they should be worried about a flow down clause, then that subcontractor should really consider walking away. In no case should a prime contractor be resistant in sharing a contractor with a sub. Certainly they can redact the contract if there is proprietary information in there that they're not prepared to share with the subtrade. But if they're not prepared to share the contract at all with the subtrade, then that subtrade should take that as the warning sign that it truly is.
Okay, fantastic. And Tim, you live and breathe this stuff. What do you have to say about this?
Yeah, I run into this all the time now. Owners council or owners just don't want to release the head contract. This is, I just tell them, look at your own contract. You've incorporated by reference the prime contract terms and conditions. You have to release it. Otherwise, it becomes an impossibility to enter into a subcontract without reviewing the head terms and conditions. The other thing I'll note under Section 41 of the Lien Act, you as a subcontractor, if they don't want to release that information and you've already engaged in a contract, or you've probably already signed a contract without reviewing the head contract, and they still refuse to release it to you, you can actually request as a lien holder, not as a lien claimant, but as a lien holder, which you are once you've signed a contract. You can request that information, including the contract price. So the head contract price. So, those are the little things, the little tools that are often overlooked that are really, really effective and should be used by a lot of the trades and subs.
Yeah, fantastic. I'll just also draw everyone's attention. Leslie here with BCCA put a link into a webinar series that the Canadian Construction Association is putting on right now. I'm a part of the folks leading it, called How to Read Your Contract. So, how does this all relate to Closeout? Well, there's, certainly, your contract's going to detail, all of this information as we go through it. So thanks. And Tim, I'm going to keep you in the hot seat here as we move into the timeline of statutory activities. So as everyone will be able to see in the guide, we have provided something of a timeline to help everybody understand those Builders Lien Act time frames, because it's certainly not straightforward. So Tim?
So before I jump into this chart, I want to again reiterate that under Section 42(2) of the Lien Act, no party can contract out of the Lien Act. So if someone asks you to sign a document or to waive your lien rights, which a lot of American companies seem to want to do lately, it's null and void. So if you're ever being asked to do that, just point them to Section 42(2) and say, look, that won't work for us. It would be void anyway, so we're wasting a bunch of time. So that's the particular section that we mentioned earlier. With respect to your timeline so the same triggering events under the Lien Act are used for both your lien filing deadlines and also your holdback deadlines for the owner to pay out your holdback, subject to any terms in the contract. So this chart nicely summarizes the Builders Lien Act requirements to have the 45-day period and the 55-day period triggered. So as you can see at the top left corner, you have to, as a sub-trade or as a GC, you have to request a certificate of completion. It's really important. An owner or a GC cannot unilaterally issue a certificate of completion. You have to request it. So if they just issue one to you without you having asked for one, it's completely invalid. Once you actually request a certificate, the consultant must, assuming you have a consultant, if there is no consultant, it would be the GC and the owner acting jointly with respect to a subcontract application. But assuming there is a consultant, you apply to the consultant, they have to respond within 10 days and either issue a certificate or refuse to issue one and provide you reasons for their refusal. Again, the issuance is something that judges have held means something more than simply creating a certificate and leaving it in their documents and in a consultant's document folder. They have to actually circulate it, send it to someone, to you, so you're aware that this thing was issued. So there's been cases where a consultant simply creates it and then doesn't circulate it, which sounds silly, but issue means something proactive. So once the certificate has been issued, the consultant, the payment certifier, must then also post a notice of certificate of completion, which is actually a different document, makes it more complicated under the Lien Act. But those two documents are different. So they must circulate that document and then also post it in a prominent place on the job site. So usually that's your site trailer or where the toolbox meetings are held in the morning. They have to post that thing. So everyone on site is deemed to be aware of the certificate having been issued. So once that certificate is issued, your 45-day lien filing period is triggered. And also your 55-day lien filing period is triggered from the issuance date. Now, I will note that this whole scenario is based on a certificate having been issued. There is under the Act also what we call a deeming provision, which requires no certificate to be issued, but might deem the head contract to have been completed or abandoned or terminated. So unfortunately, it's a much more complicated answer to all of this than simply looking at, hey, has a certificate been issued? And then you betting that you have, or you might have 45 calendar days to register a lien. It may have in fact been triggered before the issuance of the certificate under the deeming provision of the Act. So be very, very careful. If you're unsure, call a lawyer, because I have seen it over and over again that a head contract may have been deemed completed prior to issuance of a certificate and they missed out on the 45-day deadline. And under the deeming provision, it would actually be the 3-2-1 formula as well. So if a consultant certifies a head contract complete, they would look only to the 3-2-1 formula. And also, if the head contract could be deemed completed without a certificate, they would also look at the 3-2-1 formula under the Act.
Great.
I hope I didn't
Tim, this is
overcomplicate
probably,
that.
no. Well, I mean, I think the point though is that it is complicated, and that's why construction lawyers are needed. And you know, kind of why we've tried to summarize all of this together. And I will say, not that we want to make everything litigious or legal in nature, but you know, like Tim outlined, that this is complicated stuff. So when it comes to the BLA, you know, you may be well served to contact experienced construction underlined bold lawyer, you know, here in BC that's you know, familiar with the BLA. Thanks, Tim. So other parts of kind of our timeline of activities, we have kind of our contractual items. So this is substantial performance of the work, which previous to the CCDC 2 2020 and the CCA 1 2021, that was that major milestone of substantial performance of the work. And then, you know, it still exists within the CCDC 2 2020. However, it's taking a back seat to that ready for takeover one. And Terry, if I could hand it over to you to take maybe one at a time and try to shine some light on that item.
Thanks, Katie. Yeah, as has been discussed earlier here, the BC Lien Act takes precedent. The law of the land rules, that's both in the Builders Lien Act and it's also in the CCDC 2 contract. So that term that for half a century for me was called substantial performance of the work was the moment in time when the contractor gave care, custody, and control of the improvement to the owner. Now it relates to this earlier time frame, and there are differences between what's required statutorily and what may be required contractually. So for instance, the BC Builders Lien Act just requires a request from the trade or the subtrade to trigger the process to review whether or not the lien holder has met the requirements. But there might be contractual obligations beyond what the Lien Act calls for. In other words, your contract might say, give a written request, provide a copy to the general contractor and the owner, provide a list of work to be corrected or completed. So they are two separate milestones now within your contract. The one that is the law, which there's no wiggle room, you know, we comply with the law. But then there'll be these contractual obligations that may have been added to your contract. And when you sign the contract, you agree to the terms and conditions of that. So you've got potentially those two separate milestones. One, substantial performance of the work as required by the Lien Act, and potentially and more likely one required by your contract language. So that's why Katie was saying earlier, there's different timelines, there could be different applications. You have to be aware of this separation of these two potential milestones within your contract, the one that the law requires and the one that the contract requires. And then there is this new milestone at the moment in time when the care, custody, and control of the improvement rolls over from the contractor or the trade to the owner or the GC. That's this ready for takeover language that we're talking about, this new term. And it's now that transition in time. Now, the benefit of the separation of the statutory requirements and the contractual requirements is that more likely than previously, you can apply for your lien holdback well before you've met your contractual obligations to turn the building over to the owner. In the CCDC2 right now, there are 8 prerequisites that are required by the contractor before he can apply to say, I'm ready to give you the building, I'm ready for takeover. So you've got to keep in mind now that we've separated the legal requirements versus the contractual requirements, that there are different milestones and different points within that contractual time period that you need to be aware of. The plus for contractors and trades is the opportunity to more than likely get your holdback money out earlier. The plus for owners and consultants is that now there is more detailed requirements before the contractor can turn the building over to the owner. So you really need to read through the fine print. It's a shift in the way we've done business for quite a while. And I want to add, CCDC right now, CCDC has a total of 12 contracts. The other 11 are being rewritten to clearly separate the statutory requirements versus the contractual requirements. So this isn't only going to be on a CCDC2 right now, they're rewriting the construction management contracts, they're rewriting the design build contracts, cost plus, and within the next year or two, all the contracts that come out are going to recognize this distinction between what the law requires and what you've agreed to when you sign your contract. Katie?
Yeah, absolutely. Thank you for that. And I'll just remind folks, please put your questions in the Q&A. We'll either answer them by typing them in, or we'll answer them live at the end or as we go here. And yeah, I mean, I guess just a point, the intent of CCDC is that substantial performance of the work equals the Builders Lien Act requirements. And, you know, this is true. You can't contract out of the Builders Lien Act. But when it comes to the release of holdback, which is, you know, probably your profit in the project is being held back. You know, this is, again, why we're asking people, you know, to make sure that you're keeping that separate, using the correct language, you know, wanting a certificate of completion issued, you know, and trying not to muddy the waters between what the contract says as their terminology and what the Builders Lien Act says as well. So we'll move on to what we call Deeper Dive 1.1, which is some project startup best practices for project closeout. So setting the stage, you know, for project closeout right from the beginning. And I'll hand it over to Eric to kind of walk through these items as well as, you know, what he does as a senior PM. Eric?
Thank you, Katie. Yeah, all projects, of course, we're going to have a startup meeting where you establish communications, timelines, you know, how to handle changes, etc. And this is also an opportune time to deal with closeout. You're dealing with things well in advance, and you can foresee what's happening as you're going through the project and communicate that with the other stakeholders and subtrades in the project. So at this time, we usually have all stakeholders involved, which is advantageous, so that owners, reps, all of those people are involved in the process and know what's happening. The Builders Lien Act, of course, gives you some variation on closeout. It's the 3-2-1 formula. Or you can also utilize suitable for purposes intended. We often, when we're doing improvements, renovation work, etc., we'll discuss at the very beginning, if the 3-2-1 formula is most suitable, or if we're going to be utilizing suitable for purposes intended as the criteria for substantial completion. It's important to have this in place because this allows us to communicate, as I said, to trades throughout the course of the project and as you're approaching the end of the projects. The other thing that we like to do is to establish costs for key items. Often this is sort of in conjunction with our discussions about the schedule of values and how to apply or where we're going to apply certain values to the cost and break them down. Lines for demobilization, O&M manuals, as-builts, and any other closeout items that might be relevant at the time are good to discuss at this time. Sometimes O&M manuals can have a fairly high cost attached to them, and a discussion very early on in the process can probably temper it, and you can come to a fair assessment of what O&M and as-builts will come to, something that will provide incentives to complete, but at the same time not impact your final closeout and your final billing. And if you're working on the 3-2-1 formula, your calculation for completion. So you also want to discuss, what closeout is going to look like, in particular, now that we have a new milestone ready for takeover. This could entail discussions about any phased work or any impacts for equipment that will be installed in the later stages. Any potential for work that won't be completed because of seasonal deficiencies, etc. Those sorts of things, you can see the schedule. It may not come to fruition, but it's good to discuss and really sort of establish some parameters up front about that. Finally, phased work can also impact you. When you have phased work and you have partial takeover of a project without substantial completion, you might have triggering of warranties on, or at least equipment that's put into use in advance of substantial completion, and that in itself should trigger warranties. And those sorts of discussions can happen up front, and we have had them, and we have had sort of agreements in place prior to that. Warranty timelines will start at the time they're put into use. Establishing that process, it really varies. There's no sort of written criteria that tells you that this is specifically how we're going to do it. So you do have to come to an agreement and put it into writing in some fashion. And I think being upfront about things will also provide a sense of the group working together. If you're being upfront about things, people can express concerns early. And I think this is really conducive to having a good working relationship with all of the stakeholders. Back to you, Katie.
Awesome, thanks, Eric. And you touched on a couple of key points that are outlined in the guide. That includes deferred work and O&M manuals, and let's just say some of the challenges associated with them. So we're actually going to touch on those items a little bit later on, but they are covered in more detail in the guide. Same thing with having those conversations about early occupancy and partial occupancy by the owner. So that's also in the guide. And I will say, you know, Eric, you touched on some of the, let's say, ridiculous overvaluation, particularly of O&M manual items. And that's also touched on in the guide. And Tim gave us some really good kind of legal information. So I would direct you all to the guide for those specifics as well. So thank you for that. And I move on here to a couple of our activities that we're recommending contractors do, and that's around milestone inspections as it relates to substantial completion under the BLA, getting that certificate of completion, substantial performance of the work, the contractual milestone, as well as, you know, again, kind of the big one, ready for takeover. So Terry, I'll hand this over to you to kind of outline why this is important and how it should proceed.
Thanks, Katie. And, you know, good point. On all three of these milestones, you're toward the end of the project. If you're using 3-2-1 formula, you're very close to the end of the project, probably 90-95% done. Yeah, at this time, the owner, the consultants, and the contractors are looking forward to completion of the project. And so it makes sense for you, either as a general or a trade, to do the inspections, even if they're not necessarily required contractually. For instance, the BC Builders Lien Act does not require a list of any work to be completed or corrected. It's just the request that triggers that. But from your perspective, you want the project to wind up. You want to get your money out as soon as you can, whether it's the lien holdback or the final payment. So from a proactive perspective, you should be doing these milestone inspections for a couple of reasons. From the lien, on the lien side, you're going to want to make sure that when you make that request to the payment certifier to get your certificate of completion, that in fact you are complete. You don't want to have the payment certifier do an inspection, find you haven't met the milestone, and lose another month or two before you get your money out. So well before you have actually achieved that, you should be doing this inspection to make sure that you're achieving that milestone, either 3-2-1 formula or substantially performed, substantially complete as per the Lien Act. And the other value add is that from the general's contractor perspective, they can see where the trades have got some work to do. And the trades can also do their own inspection and see if they've got some subs that got some work to be corrected or completed. Again, you want that money out as soon as you can get it. We're in tight cash flow situation right now. And so you can be proactive and make sure that there's no hurdles when you're doing your inspection. Exactly the same on the contractual obligation for substantial performance of the work, if they've added in conditions beyond what the Lien Act requires. And one of them could be a list of work to be corrected or completed. So again, you want to do that proactively. You want to get that list. You want to see that you've reached that milestone so that the consultant can do his work and issue confirmation that you've reached that milestone. Similarly, ready for takeover. When you're getting ready to turn the building over to the owner, turn the care, custody, and control, and that means the expenses and the insurance and the warranties all are triggered by that date. You want to make sure that you've met your contractual obligations. CCDC 2 already identifies that the general contractor must provide a list to the consultant of any and all work that needs to be corrected or completed. That's a contractual obligation. So again, you should be doing that well before you meet that milestone. If you think you're 2 or 3 months away from meeting the ready for takeover date. You should be walking the site, doing the inspection, notifying the trades, listing what needs to be done, picking up your own deficiencies, because again, that money's going to be held back from you. When you achieve ready for takeover, any work to be corrected or completed is going to be held back from your next payment. So because you want cash flow, it's well worth spending a little bit of time and doing those inspections. Inform everybody. And another best practice is to let the consultants know ahead of time, a month or two ahead. We think we're going to achieve the requirements of the Lean Act by the end of May. Give them a heads up, and we will provide you with blah, 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 whatever is required, and we'll walk the site with you. Give them a heads up so that they're ready, because again, as soon as they sign the certificate of completion, the clock starts ticking for the release of your money. And again, exactly the same at the ready for takeover milestone. Whatever you can do to facilitate that certificate being issued or that written confirmation that you reached the milestone means you get your money earlier. It means you stop spending money on the site because the care, custody and control rolls over to the owner. So you stop paying for utilities, light, heat, security, all of those things. So as a best practice, it just makes good sense to do those inspections on an ongoing basis for each of those 3 milestones, and also proactively reach out to your consultant and advise them that you think you're nearing the milestones and that you hope to be finalizing your request by a certain date, end of the month, middle of the month, whatever it is. You just want to grease the skids to make sure you get your money as soon as you're entitled, and not necessarily have something delayed because you weren't quite proactive at the front end. Katie?
Yeah, exactly. And I think if you, there's a lot of supplementary conditions out there as well, that if the consultant has to go out more than once to the site for a lot of these milestones, those supplementary conditions, not all of them, again, read your contract documents, but it might state that the contractor is on the hook. And if there's a flow down provision, that might go down onto the subcontractors. So, you know, again, this is a best practice that we think could, you know, could help you guys as you try to achieve closeout. I'll just make a note. We're getting a lot of questions in the chat about the differences between the 2008 and the 2020, as well as some of the changes that occurred with the CCA 1 2021. We're putting in the information to some of the education courses that the regional construction associations, your local construction associations, are hosting. So that's the type of information that they'll be going into, and we're just providing that overview today of this guide. So take a look in the chat for kind of more resources for you. I will hand it over again to Tim, and we're at 12:50 right now, and we're ending at 1:30. Tim, as you go through this slide, I wonder if you could answer verbally what happens if the payment certifier doesn't respond to these requests. That was a question in the Q&A as well. So Tim, maybe kind of walk through these important sections of the VLA for us.
Okay, no problem. So I'll start with section 41. I raised this section earlier during my last presentation. It's really a useful section, because if you go to it, it reads, a lien holder or a beneficiary of a trust under this act may at any time by written request certain pieces of information. So it doesn't actually require you to be a lien claimant, meaning that you've registered a lien. You can merely be a lien holder. So if you're a GC sub or sub and you've done work on that project, you're a lien holder. So you have an absolute right to request and be given the information that's set out in section 41. So under that section, you can request from the project owner the terms of the head contract, including the names of the parties, you know that already. The key part to this is the contract price and the state of accounts between the owner and the head contractor. So this is a super powerful tool, because oftentimes, as you know, the head contract price is not provided, or it's a big secret on site. Well, you could use this section to actually demand disclosure of that prime contract price. You can also request name and address of the savings institution in which the holdback account or where the holdback account has been open, and the account number. You're probably not going to be entitled to see into it, but at least you would be given the info for that account. So it's likely that there's money in the account, let's hope. You can be given the particulars of credits to and payments from the holdback account. And you can be given the particulars of any labor and material payment bonds between the owner and the GC, and also performance bonds. So that's very important, because oftentimes you might have missed your lien rights. So this comes into particular use when you're a subcontractor, and for example, you've done work, you've gone unpaid, or even a material supplier, and you're looking to be paid your money. You've lost out on your lien filing period, and now you wish to still recover your money, but strengthen your hand. Well, you could do that by verifying whether a bond has been placed on the project, particularly a labor and material payment bond, under which you would be a benefiting party. So you could actually file a claim under that bond with the owner and the GC, and you might get a good outcome through that route as well. You can this section also flows both ways. So I will note that the owner may request in writing from a subcontractor when a claim of lien has been filed, or written notice of a claim has been received by the owner and the contractor at any time. They can request terms of the subcontract, including the state of accounts, which is also a very powerful tool for an owner to use, and any labor and material payment bonds down the contractual chain. You can also use the, under a different section of the Lien Act, you have a right to request from the payment certifier or the consultant under contract. You can send a written request to them at the very beginning of the project on day one, for example, and you can say, look, I want to be notified as soon as any certificate is issued, any certificate is issued. So you can say for the GC, for the subcontractor, even a sub below you, above you, if you're a subcontractor. So as soon as a certificate would be issued, you're statutorily entitled to receive notice of that, which is a really useful tool, because that way, if you're already off site, you don't have to continue to check whether the notice of certification of completion has been posted in a prominent place. So I just wanted to raise that, because a lot of clients, I'll just send a request under that section of the Act and say, give my client notice if and when a certificate is issued. Now I'm going to move on to Section 7, which deals with the certification and the payment certifier obligations. So a payment certifier, if there is one, I want to stress there has to be someone nominated under the contract. The Builders Lien Act deals with this issue. If there is no one nominated, with respect to a subcontractor, it would be jointly by the owner and the GC. And if it's the general contractor seeking a certificate, it would simply be the owner who deals with the evaluation of whether they are substantially complete under the Act. So under Section 7, it's a very, there's strong language making a payment certifier liable for either failing or refusing unreasonably to issue a certificate of completion within time or at all. So they are, if they're not aware of their obligations under the Act, you can certainly make them aware of their obligations, and it is a serious issue if they fail to issue a certificate when in fact your subcontract may have been completed under the Act, and you might lose out on your 45-day lien filing period because of their oversight or refusal to issue one. You would have a clear case for going after a payment certifier who's screwed this up. You could seek damages against them, depending on the factual complexity. But if they unreasonably refuse to issue one, you clearly have a claim against them. And as you might already know, they have 10 calendar days to issue a certificate from receiving a request for one.
Right. Thanks, Tim. Kind of, as you're talking, this is obviously not, anything to do with the BLA is not a straightforward process, I would say. And in the chat there, we've provided the link to a May 30th course on the Builders Lien Act. So I know that there's a lot of questions coming through. That's probably a great place to start, and we'll see, about answering some of those, if we've got the time. But definitely take a look at those links, go through that there. And I think the other part of this, you've got kind of more reading to do, but go and check out section 41 that Tim's referenced here a couple of times. Get familiar with that section as well as your rights there. So Tim chuckled at this slide as I was drafting it up here about May being the worst word in the BLA. So this all relates to the release of your holdback funds, both for the subs and for head contractors under the BLA. So yeah, Tim, I'll give this one over to you to kind of maybe outline this important part.
Yeah, so this, I don't want to go too far into the weeds, but the key term here is may. It's not must, or shall. So under the BLA, the payment out of holdback is not obligatory, it's permissive. So if, for example, the CCDC2, the 2008 version, has language in it, standard language, assuming it's not amended via supplementary conditions, that requires payment out of the holdback on the 56th calendar day following certification of completion. But if that is overridden, or if you have a bespoke contract that doesn't contain such language, the owner has no obligation to release that holdback money to the GC at the end of that period. That is something that the BLA considers a contractual payment term issue. So once the 55-day holdback period ceases to exist, the BLA stops having relevance to that holdback money, because it says, look, if the owner still holds your holdback money, then and they're not required under the contract, the terms of the contract, to release it to you on the 56th day, and there are certain other preconditions to its release, then those contractual terms are valid, because this section 4 does not use the word shall. So you're not, in fact, overriding the obligations under the Lien Act or getting rid of requirements under the Lien Act. So this is something with which a lot of people struggle, because it's to me, the may introduces a lot of questions for lien claimants, especially if they've filed a lien and it has been secured by section 24, section 23 under the Lien Act, and it's no longer on title. Well, the owner may still not want to release it to the GC. And even if they do release it to the GC might not want to release it down the contractual chain. So it's a big issue. And when I raise it for clients, I would say 99 out of 100 times, they're extremely surprised about this. So in this topic as well, if you do miss your lien filing period, and I'll talk about this, I think, later on as well, but there is potential ways around that to protect your rights under the Act. But it gets very complicated, and it's a topic that's very narrow. So I'm gonna let Katie move on with the slides.
Yeah, thanks, Tim. And I think if anyone's real takeaway here is that if you're looking for your holdback money, go look at your contract. you know, your lien rights are going to be covered under the BLA, you know, and that lien timeline is covered there, but your money is going to be covered by your contract. And maybe just a further point, you know, we've talked about it a couple of times. So prompt payment legislation, we would anticipate that it would mandate the release of the holdback money. It would no longer be may. It would no longer be that person's permissive may. So another reason, you know, we're always talking to government about this, but you know, your voices probably matter most. So you know, reach out to your elected officials on this one, because this is critical. Well, kind of, you know, Tim, you've covered a lot of this, you know, as you were speaking there, but I'll point out that, you know, the holdback funds for a subcontractor to get their progressive release of their holdback is going to go to the head contractor. Now, in BCCA's view, when that head contractor, when the GC gets that subcontractor's pro rata portion of the lien holdback, it should be released to the subcontractor, notwithstanding any reasonable contract requirements. And that might be stuff like your WCB clearance, a CC DC9B stat deck, something like that. But maybe I'll look to Randy here. You know, Randy, you work for a subcontractor. I mean, what are your tips and tricks, and you know, have you been successful in the past of getting that progressive release of your lien holdback?
Thanks, Katie. I don't know that I'm actually probably the best subcontractor to talk about this, because most of the time we're there right to the bitter end, and you know, progressive release of holdback very seldom comes to play for us, although it has happened on the odd occasion in the past. Certainly, as we've mentioned a number of times through this today, one of the things that you absolutely want to do if you're looking for progressive release of your holdback is to start that conversation very early in the process, so that the requirements around that progressive release are well understood and well known, and you're able to iron out any of the wrinkles that crop up early in the process, long before you get to the point where you actually are looking for that progressive release. I know when we've played the role of prime contractor, and as a matter of fact, on one of the projects that we're currently on right now, there will be a big lag in the project. And one of our subcontractors is looking for progressive release of their holdback because they are a small subcontractor and the amount of money is significant to them. And so as a result, they have come to us and are looking for progressive release of that holdback. There's nothing within the contract that addresses it. So nothing within the Lien Act, obviously, that addresses it. The decision falls to us. It really comes down to a relationship thing for us and the way that we look at it. On the other projects where we have been looking for progressive release of holdback, because maybe we have, you know, the largest part of our scope done and are held up possibly, you know, maybe we have to connect some landscape lighting and are held off waiting for the landscaper to finish their work. Typically, we do try and start that discussion early on in the process to make sure that things are set up for that, and get our consultants on board. That's also an important point. And we've always have to have a good reason, or anybody that's coming to you for a progressive release of holdback, there has to be justifiable explanation for why they're looking for it. They can't just come forward and say, you know, it would be more convenient for me if you paid my holdback now. So yeah, I think that's all I can offer up there, Katie.
No, that's great. And I think, you know, you hit on an important part. You know, and Tim, I'll throw it over to you here quickly, but there is no provision in the BLA for the issuance of the certificate of completion when it's a portion or a phase of a multi-phase contract, subcontract, or any kind of deferred work like landscaping that Randy mentions there. So it's only recognized for entire contracts or subcontracts. And so, you know, our guide, as well as its sister companion guide, the guide to the BLA, goes into this a little bit as well about what you can do, you know, which would be creating kind of multiple contracts, which obviously have its pros and cons to that. But I'll move on to the next slide, and Tim, and just kind of recognizing, you know, who and what for subcontractors as they seek to get that progressive release of their holdback. And Kim, if you're there, yeah, thanks.
Yeah. So the key to getting your release under Section 9 is you have to request your certificate of completion, because your subcontract cannot be deemed complete, meaning it can't be considered completed under the 321 rule without an actual certificate of completion confirming that your subcontract has been completed. So that's number one. You have to request it, and assuming it's issued, now after 55 days, assuming also that there's no further liens registered, that money will be released to the GC, and then the GC is supposed to flow it down to you. I think I've covered this, Katie. I don't want to spend too much time. We're running a bit.
Yeah, we're lots to cover, and I want to make sure that we get a bit of time for Q&A. I'll probably just note really clearly for the subcontractors here on the line, you have a statutory right to contact the payment certifier. So don't be afraid to contact the payment certifier, who might be the consultants, and we all know the kind of chain of command that exists. Yeah, they're the payment certifier. So don't be afraid to contact them when you're allowed to under the BLA. Okay, so Eric, looking to you to just briefly touch on those lovely O&M manuals and maybe some best practices that can go along with making them maybe a little bit less painful for everybody. Eric?
Yeah, I mean, the O&Ms end up being the most painful because everyone has lost their momentum at the end of the project, and it's a big chunk of paperwork that usually has to get in, and there's usually a big chunk of money attached to it. And I think that's part of the reason that that there's always a discussion about a lot of money, or sort of a moderate amount of money assigned to these, but they do have an impact on your closeout. They can have an impact on your 321 formula, which can impact your substantial depending on the timing. So it's really good to get started on them early. We like to get started 75% of the way through the project. It's something you just start assembling. Usually there's 3 milestones that we'll have with O&M manuals. Usually there's a request for a table of contents. So we will send that out digitally, have that reviewed. Often the table of contents will, give you an idea as to what's missing, and you'll get some feedback on that. The second part, I think most people as part of practice do this, is we'll send out a digital format with a link just for review. Again, you may get some feedback, sort of indicating as to what you should put in your final. This avoids the process of having to send out individual pages and punch holes and add components to binders. And then, of course, there's the final stage where you do send out the binders with thumb drives. They're usually requested these days. And one key item I just add to all of this is that when you send out your final manuals, request something back from consultants. Often the wind is out of the sails for everybody on the project, and sometimes you don't get a response, and 6 weeks later somebody says, oh, this is missing. So it's really good to close out that process, as with all other processes in the project. Back to you, Katie.
Thanks. And this also ties in nicely to the ready for takeover milestone. So under 12.1.1 of the CCDC 2 2020, there is an expectation that there are reasonably ready O&M manuals, not completely ready. But again, you want to be reading those supplementary conditions, because I'm seeing out there owners changing that to say they have to be completely finished in order for you to achieve that major contractual milestone of ready for takeover. So it's tricky out there. Can't say it enough. Read your contract, read those supplementary conditions, and that's especially true for the subcontractors out there getting a hold of the prime contract. Is anyone sick of hearing this yet? I can't say it enough. It's a lot of the calls that I receive. So I'll cover this one, and Terry, if you have anything to add, but this is right out of our guide to the Builders Lien Act. And so if your contract includes a large amount of seasonal work, you might be waiting for quite a while to receive your lien holdback funds. You might want to think about separating out that seasonal work into a second contract. Now that is valid for a general contractor, and having that discussion kind of early on, pre-contract signing with the owner and the consultant. But you know, switch out the word seasonal, you know, for other aspects of the work. If you're electrical or mechanical as well, you know, and looking at having a second contract so that you can assist in getting that lien holdback funds as well. So Terry, am I missing anything there?
No, I think it's important to recognize, as you said earlier, that the BC Lien Act doesn't recognize deferred work. So whereas your CCDC contract does, such as landscaping, you can defer it until the weather permits. If you look at this concept of a second contract, then you meet the conditions of the Lien Act to allow that first contract, that reduced contract, to have to meet the thresholds that are required by the Lien Act. So it's something to keep in mind, and it's also important right now with our supply chain issues. There's sometimes you can't get some of the components, but the owner wants to move in. You may want to also look at pulling that out of your contract until a supply chain catches up and you're able to get those final bits and pieces for your contractual obligations.
Okay. Thanks, Terry. Okay, so it says right there on the screen, this guide is just the start. Randy, could you just maybe outline, you know, why this education is so important in our industry?
Yeah, sure, Katie. Anybody who's sat through any of my rants and raves will know that I'm a big proponent of continued education. Continued education got me a long way in this industry. I started out in the industry at the bottom, and I've worked my way up the ladder to some degree anyway. And all of that is a result of education. I've reached out beyond the industry and into the local community to get that education as well as within the industry. It was said earlier that they're revisiting all of the CCDC contracts that are out there. So everything you know about the CCDC contracts now is only current now. As time goes by, that knowledge is going to start to wane, and you will need to be educated on those new CCDC contracts. So it's important that you keep up your education. Don't make it stagnant. Reach out for the resources that are out there. We definitely have very good resources in our industry. Yeah, this guide, if it's whetted your appetite for education and that's the start only, then we've done a really good thing here. So thank you.
Awesome. And I think, you know, again, there are links within the chat to CCA's, you know, how to read your contracts free webinar series. There are links in the chat to more information and webinar series on the Builders Lien Act and the new CCDC 2 2020. So, you know, reach out to your local construction association, get information. You know, I know everybody gets a lot of emails, but those emails, when they're coming from your construction association, there's good stuff in there, and there's, you know, free stuff in there. So, please, you know, reach out to them for more information about more education. So, just in summary, before we head to the Q&A, really, you know, knowledge is power. So plan from the closeout right from the very beginning. You want to keep your requirements separate, and I know some of the Q&A goes to this, so we'll talk about it. You want to keep the BLA, your certificate of completion, and the substantial performance of the work separate. You know, make separate requests referencing specific items. And again, read your contract, follow your contract, use your contract. Don't be afraid of it. I'll just give a brief story here. I had a contractor reach out to me. They had an issue. They were like, can the owner ask you know, this of us? And I said, well, like, what does your contract say? What had happened was they'd bid to a municipal owner that they've done a ton of work with, but they didn't read all the contract documents. They figured it was the same contract documents they'd seen from them a million times. Well, that owner just switched to the new CCDC 2 2020. There's new supplementaries, they have new requirements, and basically, very long story short, half their profit is gone. because they didn't see that change and they didn't read them. So you might have a lot of owners out there that you're used to working with, subs, a lot of GCs, but things are changing with this new CCDC 2 2020 and the CCA 1 2021. So if you think you got away with it in the past, this might be the contract you can't. And it might have a real impact on your business and on your, quite frankly, your career as well. So again, enforce your rights under the BLA and also under your contract, and keep in mind that it's not personal, it's business. So this is a relationship business for sure, but it's still a business. And I think, don't be afraid of pointing out, items. Again, knowledge is power. And I just maybe kind of, end it is, we haven't touched on close to half of what is in the guide. So we go into a lot of detail about, deficient work, deficiency management, so dive into that, do a word search for some of the topics that you're looking for, and then also read that sister guide for the BLA. So I'll end our formal presentation right there, and we'll jump into some Q&A. So I'll open this to Terry, this question here from Colette. What happens if the holdback is not released on the 56th day? So this looks like this is somebody who's under a CCDC contract.
Thanks, Katie. So in the new CCDC 2 2020 and the CCA 1 2021, there is a contractual obligation to release the holdback. So whereas Tim pointed out that the law says may, it's a contractual obligation in both the CCDC 2 and the CCA 1, the new copies. So then you can rely on the language in your contract because you're not in default or you're not overriding what the act says. And if the party doesn't release it, there's a little more time. It's typically 10 days, 10 working days, but it allows you to then require it contractually. And if they're still not requiring it, it's a breach of your contract.
So maybe on that same kind of topic, if the owner isn't paying the progress claims, does the GC have the right to stop work? Eric?
Yes, I mean, as long as you follow the processes outlined in the contract under defaults, you have to provide written notice. You have to state your reasons, and a process will be involved, and you have to give the owner time to respond. So yes, you do, but with process.
Yeah, maybe I'll just add, I've had, conversations with contractors where they're like, we want to know our lien rights because we haven't been paid in 4 months. And it's like, why are you still working at that point? Focus on your contract. Don't be waiting for your lien rights. So Tim, we've got a question here from James. Does progressive release of holdback apply to sub-subs or just that first tier subcontractors?
No, it goes all the way down the contractual chain. So the Builders Lien Act defines contract, contractor, and subcontractor. And if you look at the definition, subcontractor is defined as anyone, the subcontractor itself or anyone hired or engaged under that subcontractor. So you're absolutely entitled to use the progressive release regime as a sub-sub or sub-sub.
Okay. We have a question here from Clint, which, Tim, I'll keep this with you and maybe just clarify here for Clint. Does the ready for takeover trigger the 45-day lien period?
No. Anything contractual has absolutely no impact on the statutory certification procedure. So the act is clear. The head contract can be certified complete using the 3-2-1 rule, or the subcontract can be certified complete using the 3-2-1 rule. So whether or not the contract seeks to override this requirement or this formula matters absolutely not. So if the contract is complete using that formula, that's it. That the certificate of completion should be issued. I do know a lot of times consultants seek to rely on, valuing a deficiency, for example, that's 10 grand actual cost to correct it, and then they'll double it because they either think that this is common to do, to double the value of a deficiency, or a contract term says, look, we can value it at 200% of the actual cost to correct. I would argue also that they cannot double that and take the doubled value into consideration for the 3-2-1 formula. So there a lot of analysis goes into that, but no contractual terms have any impact on the 3-2-1 formula.
Yeah, and the lien period. So it's, there's, a contract can't touch that, either. And I'll just say again, we go into some of those details about, deficiency management, your deficiency holdback, we go into that within the guide. And, Tim, of course, is absolutely right that, the 3-2-1 is just a strict mathematical formulation. You're not doubling stuff just because it says that in the contract if they've allowed themselves to do it. We have a question here. I'll throw this to Terry and then anyone else can add on there, but this is around, Alan asks, is there a recommended timeline to complete the punch list / incomplete items after approval of the substantial completion certificate? So, I know for me, I would need some more clarity around what kind of language we're talking about, but Terry, can I, ask you to touch on that one, and maybe going into a little bit about ready for takeover, which is really where that list comes into play as well.
Yeah, it is required by the contract in CCDC 2 for the contractor to prepare that list. And you should, if you can, evaluate that as well. And that it occurs at ready for takeover, not at the new substantial performance of the work, which is the contractual link that's tied to the lien act of the jurisdiction. So I don't know if that's answered the question or anyone else has got something to add.
No. Yeah, it's I like I said, I think that the language that's being used there, the list as it relates to substantial performance of the work, Terry or Eric, correct me if I'm wrong here, but that's completed by the consultant and is not an impact to the substantial or getting your certificate of completion. And then for ready for takeover, it's the contractor that does the list. So you can see probably like why we've created this guide is because depending on the milestone, people are doing different things. But under the BLA, there is no requirement for any list. I mean, probably to do it, the consultant's gonna have to create one. But yeah, but it's definitely, I would read into the guide more because we definitely go into more information. And I want to go to a question, and it's a comment and a question from Amy here. This issue of the BLA utilizing the word may in regards to the holdback payment for a CCDC 2 2020 that does not have any specific supplementary conditions stating otherwise, is it not clear that the language of GC 5.4.3 that the holdback is due no later than 10 working days after the expiration of the holdback period? And I would say, yes, it is clear if it hasn't been modified. And Amy continues, so this seems like a slippery slope if this can be altered. Yes, that is an awfully slippery slope. I don't know if any of our task force members have something to add to that, but yes, it's terrifying.
We've talked about read your contract. You may have heard that in the last hour and a half, but it's a business decision. When you read those supplementary conditions, you as a contractor, a trade, or a sub have to make the business decision whether you can manage the risk that's been transferred or whether that's a good project to walk away from. Right now in our industry, there's lots of work out there. We have a capacity issue. Don't be afraid to not bid a work if the conditions are too onerous. You're better to look at another project that treats you fairly than to sign a contract that's going to put you in some really tough scenario where you're going to possibly impact your business. So don't be afraid to make the business decision to walk away from a bad project that's got some pretty onerous supplementary conditions.
Yeah, it is. I would just say, I mean, it is pretty wild out there. I think you want to be looking for contracts that have a really clear and unambiguous timeline and requirements for the release of your holdback. And same thing for subcontractors, making sure that you get a copy of that prime contract, because 99% of the time, well, let's say 95, there's probably a flow down clause, and you're going to be covered under those as well. So I'll just say, as about to hand it over here to Chris to wrap this up for us. But I hope that the guide is helpful to you. I hope it gets you, kind of thinking. If you need more education, we've got lots of links that we've provided to you. And I think, again, I mean, thank you to our task force and to Tim for all your advice and time that you've spent on this. So Chris, over to you.
Yeah, thanks very much, Katie. And just a huge thank you to Randy, Eric, and Terry for being part of the task force. And of course, to Tim for providing the subject matter expertise and the legal review that you have. And Katie, of course, for making sure that this came to the attention of our Standard Practices Committee and brought it forward and made sure it happened. So just a huge thank you to everyone involved. So much insight, experience, and thoughtfulness has been demonstrated over this past hour and a half. And you can obviously tell that a lot of that passion has gone into this new closeout guide. I feel the participants on this webinar are now much better informed and prepared for success as a result of this new resource that's available. And we're happy and pleased to be able to launch it today for all of BC's construction industry. So on behalf of BCCA and the 4 regional association partners, thank you to all our participants who took the time to sign on and learn something essential that may serve you well. And that's why we as associations exist, to serve you. So use the resources that we create and curate for your needs. And with that, we'll sign off for this afternoon. And once again, thank you for taking the time today for the launch of our closeout guide.